Okay. I think that's probably a good time to start. If people turn up as I am talking, then they will be able to work out where we've got to, hopefully. All right. Hello, everyone. Welcome. This is an interactive webinar from 42 Bedford Row Barristers. It is about tenancy deposits and Section 21 notices. My name is Iris, and this is Andrew.
Nice to see everyone.
And we're both housing law specialists at 42 Bedford Row. If you'd like to find out a bit more about us, have a look on the 42 Bedford Row website. And now, Andrew, let's get started.
Thank you, Iris. As Iris said, this is an interactive session, so you should see we're screen sharing a document there, but we'll be reading that out as we go along. We'll be asking questions and going through some scenarios together. And so if you can put your answers in the chat box, we can then go through them. And so to begin with, we'll start with what I hope is a fairly straightforward question. And it is this: if you are a landlord protecting a deposit in a tenancy deposit scheme, do you have to give the tenant any information about that scheme? Now, into the chat box, hopefully we get some good answers here. Do you have to give the tenant any information about the tenancy deposit scheme?
Don't be shy, everyone.
Don't be shy.
Type your answers into the chat, please.
Okay, so we're getting a couple of positive answers so far. And so
surely
we have Jerry.
It's not just Jerry who can use his fingers. Come on, everyone.
Well, I'm sure that everyone is thinking that that what Jerry and Shivan have said there is correct, and of course they are correct. You must give the prescribed information, which is set out in the Tenancy Deposits Prescribed Information Order 2007. So that was a nice, easy round to start with. Iris, over to you with our first scenario.
Thank you very much, Andrew. Here is a little scenario to have a think about. You have a client. Let's call him Bob. Bob is the landlord of a house in South London. The house is currently occupied by a tenant, Sylvia. Sylvia moved into the house on the 12th of July 2019 under a 6-month AST, and she paid a deposit on the same date. Bob now wants to serve a Section 21 notice on Sylvia, and you are advising him. What questions do you need to ask Bob about the deposit before you can advise him on whether he can serve a Section 21 notice? So in the chat, please type in what's missing. What do you need to know about Bob's situation before you can give any advice on whether he can serve a Section 21 notice? Okay, Yemi has given the first and best answer so far. Yemi says, was the deposit placed in a deposit scheme? Absolutely right. That is one of the key things that has to happen. Anything else? Is there anything else that you as a lawyer need to know? Shivan has a 100% record so far. Correct answer. Was the prescribed information provided? Another very important question to ask. What else might you want to ask Bob before you can advise him? So we've got placing of the deposit in a scheme. We've got providing of prescribed information. Anything else that anybody can think of that we might want to ask Bob before we can advise him? Okay, I'm going to take that as people just being shy and having lots and lots of other ideas. So what we're going to do is, Andrew, I'm going to pass it on to you. We're going to explore some of the other things you might want to think about before you can fully advise Bob.
Very good. Right. Well, let's assume, as Yemi has identified, that Bob did protect Sylvia's deposit in a tenancy deposit scheme. What's the last date that Bob could have placed the deposit into the scheme to comply with the law? Answers in the chat, and brave answers are better answers. Bravery is rewarded.
Remember, the deposit was paid on the 12th of July. So that's your
Yeah.
clue. I can see a few people who are attending. Philip Cridge, I'm talking to you. Mark Gannon, I'm talking to you. Charles Jameson, I'm talking to you. Ashley, I'm talking to you. You must surely know the answer to this very simple question. Can anybody tell us the last date Bob could have placed the deposit into the scheme that would comply with the law? Okay, Andrew, I think you're going to have to give him the answer.
Well, the answer is 30 days after the deposit was received by the landlord. So 30 days on top of the 12th of July is by the 11th of August. So that's the answer, 11th of August 2019. The next issue is, what difference would it have made if Sylvia had paid the deposit to Tony, who's Bob's letting agent, and not to Bob personally? What difference would that have made? Again, bravery is rewarded. Let's see if we can get a little bit more activity in the chat.
Would it have made any difference?
Would it have made any difference?
Answer. No,
No
okay.
difference.
Some brave.
Okay. As long as it was paid into the TDS, no difference. Well, those are both pretty good answers so far. The deposit may not have been protected.
Yeah, I mean, this is assuming, let's assume the deposit has been protected, but let's say it's the agent that did it rather than the landlord. That's the situation we're thinking about at the moment.
Well, I think we will take we'll take Sumi and Shivan's answers as representative of the consensus, and it's correct that it makes no difference if the deposit is paid to Tony. The legislation imposes obligations both on agents and landlords, and so the fact that the money was paid to Tony doesn't affect Bob's liability to both protect the deposit and to provide the prescribed information. Now, the next question is, what happens if things go wrong? What is your advice to Bob if the deposit was not put into a TDS by the time that should have been the 11th of August? What happens if it wasn't paid in? Answers in the chat.
Maybe worth saying that remember, you're advising Bob right now in September 2021 on whether or not he can serve a Section 21 notice. So that's what you're thinking about when you're looking at that question. What can Bob do? Andrew, I think you're going to have to tell them.
Well, I mean, there's, here we go, Joe McBride, capitals. Let's hope that that's not shouting, and it's, his notice is not valid, so would need to refund the deposit. Yes, that's spot on. It couldn't be put any clearer.
I think the reason Jerry's put his answer in capitals, Andrew, is it's because it's so obvious that everybody else should already have written that.
Yes.
Absolutely.
Thank you, Jerry. So on to the next on to the next scenario, Iris.
Thank you very much, Andrew. Okay, another question for you. Let's assume Bob protected the deposit in a tenancy deposit scheme. Let's assume he did that in good time before the deadline. So he did it good time before the 11th of August of 2019. What's the last date that he could lawfully have provided Sylvia with the prescribed information? I'm going to ask you a simple question, and I would like, please, everybody, that's every single person on the chat, to type in yes or no? Okay, test for everyone. You must type in either a yes or a no. Is the deadline for serving the prescribed information the same as the deadline for protecting the deposit? In other words, 30 days. Yes, it's the same, or no, it's a different deadline. Come on, everyone. I want everybody to type a yes or a no. I've got 4 people so far. Even if it's obvious, type your answer. Come on.
Especially if it's obvious, type your answer.
Especially if it's obvious. Yeah, absolutely. I've got Jerry so far. I've got Shivan, I've got Sumi, and I've got Yemi. I know from looking at the chat that there are plenty of other people that could type in that haven't so far. Maybe it's so obvious, Andrew, that people just don't feel the need to reply. Okay, the answer is obviously yes. Yes, that's correct. The prescribed information has the same deadline as the protection requirement, 30 days. Absolutely right. Okay. What if Sylvia's mum, Doreen, paid the deposit on Sylvia's behalf rather than Sylvia, the tenant, paying the deposit? Does that have an effect on the rules about prescribed information? Does that mean that anybody else needs to be sent the prescribed information? A few no's here. Well, that's not absolutely right. So a few people have said, no, it makes no difference. It does make some difference. It's correct. Jerry says it still needs to be protected and the information provided to the tenant. That's absolutely right. But the important difference is that if somebody else, by arrangement with the tenant, pays the deposit on the tenant's behalf, say, for example, mum, then that person, in this case, Doreen, also has to be served with the prescribed information as another person. So if there's a tenant and another person who paid the deposit on their behalf, then both of them, 2 people, need to be served with the prescribed information. Okay, and then finally, what do you advise if Bob tells you that the prescribed information was provided late? So remember, you're now in September 2021. Bob is telling you, I didn't know that. I didn't do it in August. I did it in the September. So it's out of time. What does that mean? What do you advise Bob about serving the Section 21 notice? What does everybody think? Let's see what you have to say in the chat about that. What advice are you going to give a solicitor, as a solicitor, what advice are you going to give a client who served the prescribed information late? Well, the answer is that it, perhaps surprisingly, for the purposes of serving a Section 21, it doesn't matter that it's late. What matters is that it has to have been served on the tenant and potentially on Doreen if she paid the deposit on behalf of Sylvia. It has to have been provided either before you serve the Section 21 notice or on the same day at the same time that you serve the Section 21 notice. Now, Bob might still be liable for a penalty claim because of the late service of the prescribed information, but in terms of serving a Section 21 notice, he will be okay as long as he provides the prescribed information before or at the same time as serving the Section 21 notice. Okay, Andrew.
Very good. So another question, and this may be so obvious that it goes without saying in the chat, but notwithstanding that, answers are mandatory. Sylvia's original AST came to an end after 6 months on the 11th of January 2020. You asked Bob if he's ever got Sylvia to sign a new fixed term tenancy agreement after that. Now, why does that matter for the purposes of serving a Section 21 notice. What's the effect of having a new fixed-term tenancy that replaces the old one or the original one? Answers in the chat.
I suppose it's a bit of a trick question, isn't it, Andrew? Perhaps.
Yes, okay. So Shivan and Jerry, both good answers. So Shivan says you need to check whether the tenant is still within a fixed term or not. And that's absolutely right. If you are within the current fixed term, the Section 21 notice can't expire, or the period can't expire before the end of the fixed term. So that's correct. Then we've got Jerry, who says Bob needs to protect if it's a new deposit. And that is potentially correct, but the Act has resolved a conflict that was in the case law on this question. Essentially, now, if you have the same parties and the same property and the same tenancy deposit scheme, the legislation treats the original protection and the original provision of the information as applying to the new tenancy, whether that's a fixed term tenancy or a periodic tenancy. So if you've done it properly on the first go, when you come to the renewal, it's treated as having been complied with. Now, over to you, Iris.
Thank you very much. Okay, let's take a look at another scenario. You have another landlord client. This one is called Trevor. Trevor owns a ground floor flat in a tower block in Finchley with a tenant, Jill, and she moved into the flat on the 30th of January 2020. Jill pays a rent of £400 each week, and Trevor took a deposit of £2,500 from her on the date that she moved in. So that's the 30th of January. Trevor did protect Jill's deposit. He did that on the 7th of February, and he provided all of the prescribed information in the correct form to Jill a week later on the 14th of February. There hasn't been a new fixed term tenancy, so Jill's tenancy became a statutory weekly tenancy at the end of the 6 months, at the end of June 2020. Okay, that's the scenario. Can Trevor now serve a valid Section 21 notice on Jill? Is there anything wrong with this picture? Is there anything in this scenario that makes a Section 21 notice invalid? Thoughts in the chat. It's a tricky one. It's a bit of a bonus question, one that is easy to miss, and I'm going to give you a clue to see if this will help jog people's Jerry. Jerry is the star of today. Yes, Jerry is absolutely right. It's the amount of the deposit that is the problem. I don't know whether you can all see the chat. I think you can, but Jerry says, is the deposit too high? And that's exactly right. The Tenant Fees Act came in on the 1st of June 2019. Under the Tenant Fees Act, any deposit taken either on or after the 1st of June 2019, so that will include Jill's deposit, any deposit taken on or after that date can only be up to a maximum of 5 weeks, the equivalent of 5 weeks rent. So in this case, 5 times 400, £2,000 would be the maximum deposit that Trevor would be allowed to take Anything above that, £2,001 deposit, makes the deposit unlawful, and no section 21 can be given in respect of that tenancy. Again, in the chat, everybody, how do you fix that? How do you fix the problem of having taken a deposit that was unlawful, that was £2,500 instead of £2,000, when that was the maximum deposit that Trevor could have taken? What's the advice you're going to give Trevor to fix the problem? In the chat. Sumi says something that is creative, but wrong. Return the difference to the tenant. Unfortunately not. The consensus is that the entire deposit is unlawful and the whole thing must be returned to the tenant. So it's a costly mistake to make, unfortunately. You can't just return the £500 to the tenant. You have to return the entire £2,500 to the tenant. Once you've done that, then there is no deposit at all in respect of that tenancy, and you can then serve your Section 21 notice after you have returned the deposit. Andrew, you've got a follow-up from that.
Yes, this flows on nicely. This next question is, what difference would it make if Trevor's flat were not a ground floor flat in a Finchley tower block, but a Kensington penthouse with 2 parking spaces at a weekly rent of £1,000? Does it make any difference that this is a high value rental property, although arguably it might be good value in Kensington for what you get? Answers in the chat.
Come on, everyone, have a think. We're still talking about the deposit cap. So we've just been talking about the fact that the normal deposit cap is 5 weeks rent, equivalent to 5 weeks rent. Is there a difference on these facts in that first bullet point?
Jerry says the deposit is within the limits now. That's correct. And the maximum deposit where the yearly rent is over £50,000, the maximum deposit can be 6 weeks and not 5 weeks. So the maximum here would be 6,000, and anything above that, that's when you need to return the deposit to the tenant. This is an extension on that previous scenario, where we're talking about a flat in Mayfair with 2 parking spaces at a weekly rent of £1,000. But in addition, Jill is moving in with 2 French bulldogs. What difference does that make? Is Trevor able to take a higher deposit because of the 2 Frenchies? Yes or no?
Again, let's have everybody typing in an answer, a yes or a no. Does it make a difference to the maximum deposit cap where there are pets in the tenancy?
Jerry McBride, no. Yemi, no. Are there any advances on the no's that we've had from Jerry and Yemi? It seems not. And that is wise, because of course they are correct. It makes no difference that you have pets. And so the 6-week cap is as applicable as in the ordinary scenario.
So in other words, Andrew, if you're a landlord and you normally take the maximum deposit, let's say in most circumstances, most rents even in London, are not £1,000 a week. So for most of the clients that you'll be seeing, you'll be talking about a 5-week maximum deposit, because it'll be under £50,000 a year rent. If your clients ordinarily take 5 weeks as their deposit, they can't take any more than that for pets. If they want to take extra for pets, I'm afraid they have to take less deposit for everybody else. So they could take a view that they would normally take 4 weeks rent equivalent as a deposit, but for a tenant who has pets, they'll take a 5-week deposit. And that's all that is allowed since the 1st of June 2019, which is a surprising outcome to the Tenant Fees Act, but that is what the Act says.
And that is what the Act provides, yeah.
Okay. Yes. So. Andrew, is there anything else that you would like to say before we move on?
No, I think back to you, Iris. That's all.
Thank you very much. Okay, let's go back then. Let's go backwards in our various scenarios to scenario 2. You'll remember this from the beginning of our session. We introduced you to Bob. We introduced you to Sylvia. We told you about Sylvia's tenancy starting in July 2019 with a deposit, but we didn't know anything more than that about Sylvia's tenancy, except that we knew that Bob wants to serve Sylvia with a Section 21 notice. And we asked what questions you would need to ask Bob before advising him whether he can serve a Section 21 notice. So let's review that now. Let's have a look again at all of the things that you would need to know if you're sitting down with Bob advising him on Section 21. So the first thing, as I think it was, oops, pardon me.
Yemi, I think.
Yeah, I think it was Yemi who said right at the beginning. That's right. So as Yemi said right at the beginning, you have to ask Bob the most obvious and most important question: was the tenancy protected in a tenancy deposit scheme? It's the first question. The second question, also extremely important: when was the tenancy protected? Because if it was protected later than the 11th of August, then a Section 21 notice is going to be invalid and you have to return the deposit before you can serve the Section 21 notice. So, to summarize, was it protected and when was it protected? The next question you're going to ask Bob is, did you provide the prescribed information to Sylvia? And you'll remember that it doesn't matter so much when that's provided, but you do need to know when it was provided, because if it was done after the 11th of August, it must be, you must make sure that it was done. So long as it was done before Bob has come to see you, it's no problem. If Bob has not served the prescribed information, then you've got to advise Bob that that needs to be served before the Section 21 notice is then served. And you need to check with Bob whether someone else paid the deposit on behalf of Sylvia, because if they did, if Doreen, Sylvia's mum, or Paul, Sylvia's dad, or anybody else at all paid the deposit on Sylvia's behalf and Bob didn't serve the prescribed information on that other person, then that has got to be done before the Section 21 notice is served. So you're going to ask Bob, did anybody else pay the deposit? And has the prescribed information been given to them as well? You're going to check with Bob, aren't you? So that's the protection of the tenancy at the right time, and that's the service of the prescribed information. Then you're going to be asking Bob, how much is the rent on this house in South London? If the rent is less than £50,000 a year, you need to know whether the deposit is less than 5 weeks rent. If the rent in South London, unlikely, is more than £50,000 a year, then the deposit needs to be less than or equal to 6 weeks of equivalent of rent. So you need to know how much the rent is, because by knowing how much the rent is, you can calculate what the cap on the maximum amount of the deposit is. Once you know that, you will know whether the deposit that was taken is too high. And if it was, you'll be advising Bob to return the entire deposit before he serves the Section 21 notice. Then you're going to be potentially asking Bob whether there is a new fixed term. Now, Andrew took you through the fact that the Deregulation Act 2015 has resolved all the complicated case law that we used to have about what to do with deposits where you enter into a new fixed term. And you know, having listened to Andrew this afternoon, that it doesn't matter if there's a new fixed term now that the Deregulation Act is in force, as long as everything has remained the same. The tenancy deposit is treated as protected so long as it was protected under the initial tenancy, the very first original tenancy. However, bear in mind that it is possible for parties to change with a new fixed term, and it is potentially possible for the description of the property to change for the new fixed term. And it is in theory possible for the scheme that the deposit is protected in to change for the new fixed term. And if any of those things has happened in the new fixed term that was signed, change of landlord, change of tenant, a change of premises, or a change of scheme, then the deposit does have to be re-protected. In other words, you've got to protect it again, and you've got to serve all of the prescribed information for the new what is effectively a new deposit. Now, when is that potentially going to happen? It sounds a bit esoteric. When are you going to have a change of parties? Well, it's not as unusual as you might think. For example, let's say it wasn't Sylvia in the house, but a group of 3 students. What if by the time Bob signs the new fixed term with them, 2 out of the 3 students have left and 2 new students have come in? Well, then we're talking about a different group of tenants. And in that situation, you may well need to re-protect a new deposit with the names of the new tenants. If Bob was previously renting out the house through a limited company, and now under the new tenancy, he's decided to rent the house under his own personal name. Again, this is something that does happen. People own property in limited companies, and they sometimes flip between their personal name as a landlord and the company as a landlord. If Bob is now the landlord and the limited company was previously the landlord, then potentially there is a change of landlord there, and there would need to be new tenancy deposit protection. If the house, let's say, has a nice big garden, but Sylvia has been neglecting the garden, for example, and Bob decides he's not going to include the garden in the tenancy this time around when he issues Sylvia the new fixed term tenancy, but instead he's going to keep the garden in outside the tenancy, and he's going to send a gardener in himself once a month to keep the garden under control. Well, in that situation, Bob is not renting to Sylvia the same property as he was previously. He is renting her a house without a garden, whereas previously it was a house with a garden. So that's an example of a situation where the substantially the premises that are being rented have changed between the old fixed term and the new fixed term, and that would require a new deposit protection process to be undertaken. So you do need to check these things. You need to, of course, be aware that most of the time, if there's been no changes, you don't need to do anything more, but you need to keep an eye out for whether there have been changes between the original tenancy and the new tenancy, fixed term tenancy, so that if there have been, you can advise Bob about what he needs to do or what he should have done in relation to the protection. And if there has been a mistake, if there was a change of parties, if there was a change in the description of the property that is significant, and as a result, the deposit should have been protected, but it wasn't, then your advice to Bob might well be, again, as with some of these other points, return the deposit. That is the simplest and sometimes the only way to resolve an unlawful deposit. Once that's done, once the deposit's been returned and Bob has got proof that the deposit has been returned, then you can advise Bob to go ahead and serve the Section 21 notice. So lots of things to think about there. Let's go to the last section again, just so that we have that up. Okay, so deposits, lots of things to think about. Extremely easy for landlords to get it wrong. And in fact, it often does happen that landlords get it wrong, as we know from the enormous amount of case law about deposits that we see going through the county courts all the time, and occasionally arriving in the higher courts as well. If you are in doubt, if you are not sure whether your client has protected a deposit lawfully, then of course, first of all, send an email to me or Andrew. We can help you to look at all of the paperwork, sort out the position, find out whether, as far as best we can work it out, whether the deposit has been validly protected. But ultimately, practically speaking, if there is uncertainty about whether the deposit is lawful, or of course, if the deposit is definitely not lawfully protected for any reason, then the practical answer, painful though it may be for Bob or Trevor, the practical answer is, if they want a relatively straightforward Section 21 possession, they are by far the best advice to them is to return the deposit. And the way that I tend to advise landlords in this situation, because landlords never want to hear that advice, is that they will very, very quickly spend that money on lawyers arguing about the validity of the deposit. And it is just easier to return the money to the tenant and not spend the money on lawyers arguing about it. If the money is returned, the deposit is returned to the tenant, there really cannot be a legal argument about it after that, so long as the Section 21 notice is served after the tenancy deposit has been returned. Okay, so Andrew, is there anything else you want to add? Is there anything else you want to say before we?
I think we've covered things. Just to emphasise that that these matters can easily come, that landlords can easily come unstuck, and that it's worth checking off in your mind even as you're going through each of these questions.
Okay, great. Thanks, Andrew. Thanks everybody for taking part and for answering questions. Now, we're going to produce a handout in the form of these questions that you've got on your screen at the moment, together with the answers to the questions that we've been running through during this session. And we will include our email addresses, mine and Andrew's, with that handout, so that you can get in touch with us if you've got any particular queries on cases that you've got running, or on any details of the deposit schemes and the Section 21 regime that you want to raise with us. So that handout will be with you shortly. In the meantime, all that's left to say is please keep an eye out on the 42 Bedford Row website for our next housing webinar. And we very much look forward to seeing you next time around. Thank you, everybody, and goodbye.